Okay, while you do that, thank you all for coming today to the Landlord Tenant Clinic training session. Today, we are joined by Sal Curran, the Executive Director of the Volunteer Lawyers Project of CNY, and Rose Marina Zender, which many of you probably know, the program coordinator for the Tenant Defense Program. And we're also joined by Sylvia. Hi. All of you at this point have participated in the clinic. However, we thought this would be a good opportunity to learn more about the clinic, our role, and have any questions you may have be answered. Without further ado, I'll turn it over to Sal.
Great, thank you so much. Yeah, so I just want to start by saying thank you all so much for doing your pro bono work. I know everybody's time is pulled in a lot of different directions, and it's a lot to step out of your normal areas of practice to come and help those in need. So we really appreciate you. We appreciate your participation in landlord tenant, tenant rights clinics, in family court clinic, which everybody does, and then also, you know, we send along cases that are maybe a little bit more closely aligned with your practice area. So thank you for that. So today we're going to run through the tenant rights clinic kind of overview. Hopefully this will be familiar to you. I do want this to be like question and answer, so feel free to jump in at any point. Also, full disclosure, I'm not in court anymore, hardly at all anymore. That would be kind of Sylvia and Gregory. So if you have questions about day-to-day practice, about what we're seeing in court, we do thankfully have Sylvia here, so that's great. Okay, so just move this out of the way. So we have the full handout. Liz Marina went ahead and put in the full handout here, so you can take notes there if you want, but I'll also just be going over it here. Okay, so our mission, Volunteer Lawyers Project, we're an independent 501c3 org. Our mission's to provide access to justice through engaging the legal community and volunteer service to those in need. So all of you are critical to our mission. We do provide you CLE credits for your pro bono work. What you'll see is towards the end of the year or the beginning of the year, reach out and say, if you want your pro bono CLE credits, just let us know, fill out the certification, and then she'll send you the proof, and you get 1 pro bono CLE credit for every 2 hours that you volunteer. So for you to do your certification, you also can affirmatively reach out to us, and we're happy to do that for you. And those can roll over. So even if you're newly admitted, you can't use them in your first 2 years of being admitted, but then you can roll them over and use them after that point. We provide primary malpractice insurance, and of course, we provide support and guidance. And for those of you who've already been at the tenant rights clinic in the morning, you know that Luz Marina is there helping you out, helping guide you through it. She's become just such an amazing, I mean, she already, prior to coming to VLP years ago, was already an amazing resource on everything, all the social service resources that people need to avoid homelessness. But now Luz Marina also really knows this area of law. And so while she's not an attorney, she can answer a lot of your questions and can help support you through things. And then at that morning clinic, Sylvia or Gregory is over in the court representing clients. And so we always are able to get a little bit of guidance from there. What to expect? Well, if you've got a notary stamp, bring it, because we do have some forms that we have people notarize. Although I will say, worst comes to worst, the verifications don't actually have to be notarized anymore. Does everybody know that? A law passed in December of this past year that made verifications be able to be done via affirmation, just like how we don't have to notarize affidavits and support anymore. They can be affirmations, but we haven't updated all of our forms with that. So it's just easier to bring your notary stamp. And if you have to cancel, please text, email, call, let Luz Marina know so that she can plan accordingly.
Is there a number for that?
Yeah, it's on the last page. Yeah.
If you need my personal cell phone, I'm willing to give that as a home.
Let me just go away. always hate that these things just kind of hang out in the way.
What does the drop down do?
We'll say.
I don't know.
Optimize or video sharing.
That everybody?
Well done, you beat me to it. Okay, so why we do this, there's really a huge housing crisis in Syracuse, and I actually didn't even update the most recent homelessness numbers on the next page. But in Syracuse, when we are talking about housing and affordability, over half of the Syracuse residents spend more than 30% of their income on housing. And it's actually every year is increasing the amount that are doing that because the rents are increasing so quickly. A third of Syracuse residents spend over 50% of their income on rent. And what that means is that if somebody has to miss a day or two of work because of a sick kiddo or them getting sick, that just missing a day or two makes it so they can no longer pay their rent, can no longer afford groceries, things like that. And right now, it's harder to find an apartment in Syracuse than in any other US city, worse than New York City. And so what we found is, 10 years ago when I was doing this training, we'd say, oh, people will they might want to just settle and relocate and they'll find a new place in a week or two. It's not like that anymore. It takes months. We over and over again have clients coming back to us where we are negotiated them having 3 or 4 months to relocate and they're coming back and they're saying, I still can't find a place I can afford. I've applied to 20 places and I still can't find a place. So really when we're doing tenant rights work now, we're trying to think about how can we get them the most time or keep them in the house they're in? Because even if the house is not the greatest quality, at least it is a place to be that hopefully has heat and hot water and hopefully a roof with no holes in it, so that they and their families can stay safe. So right now, 1 in 10 Syracuse City School students are experiencing homelessness, which to me is just really heartbreaking. And we have the highest rate of homelessness ever recorded. I have here that it has increased 40% since 2021, but I think it's actually more like 50% at this point. It's gone up. And the highest rate of homelessness is among families. And what we are seeing over and over again is the families that are coming into homelessness did not previously experience homelessness. This is the first time, it's emergency. And it's really, when you've got that situation, often folks don't even know where to go to get help. A lot of the housing relocation programs that previously existed have shut down. Part of it is because there's nowhere to go. Part of it is because there's not enough funding for it. And I do just want to say, I probably could do a slide of the bad news to come. But I mean, a lot of it is speculative at this point, but they're programs like Section 8 have already been singled out by this federal administration to be cut drastically. And if that happens, that's going to have a devastating effect on our community. The affordability of housing is such an issue that I think for many families, if they don't have a voucher right now to limit the amount that they have to contribute to 30% of their income, they simply could not afford anything. The other issue that we have is that the shelter allowance for those on temporary assistance has not increased in over 20 years. So there is no apartments in the entire state of New York that are affordable on shelter allowance.
Do they know why family homelessness has increased so much? Why families?
Ms. Rena, what have they been saying when you've been attending the Housing and Homelessness Coalition meetings? And Sylvia, I know you attended a recent one. Have they been talking a bit about that?
Just basically been saying that. Like she was talking about, like the housing market, there's no housing, and then, you have, if there's 2 family people working, it's still difficult to be able to afford the rent. Rents have gone like, I remember when I worked at the Salvation Army, we used to house people for like 500, 695, you can't even touch that right now.
No,
The rents
yeah,
are between $1,200, $1,600, $1,800, and some of those apartments are just.
yeah, so I mean, with families, trying to find apartments that are affordable with 2 or 3 or even 4 bedrooms has become almost impossible. And I do think part of it is like most of the new housing that has been built is not for families. And we've had housing come offline that was for families, and that's gonna continue to happen, you know, when they're talking about closing public housing. And giving people vouchers, well, that's great, except for where are people gonna go if, like, the vouchers aren't, if there are no houses available for the vouchers, it's very problematic, so. Yeah, that's what we're hearing in general, and
Inventory
it's
is.
inventory and affordability, you know, if you are, even if you have 2 family members earning, you know, minimum wage, affording a $2,000+ a month apartment's just not possible, you know?
And it's gonna get worse because, I call them the bricks, I'm sorry, I don't really.
Right, that's what I was talking
I
about,
don't
that they're
really
coming
know
up
the
with the
real
public
name
housing,
of them.
right by I-81 that
Yeah.
folks call the bricks.
They
they're gonna
just
come down.
put 22 people. I guess my girlfriend works. And she was sharing with me that she was trying to find housing for 22 folks in the first phase. And they weren't able to find housing for a lot of these, because there's no housing.
Yeah.
So they just are on the streets.
Yeah, and the problem too is we have a lack of transportation to the surrounding communities, you know, Central lost a lot of its roots back during COVID and never really fully restored them, and so even if they could find housing in the surrounding communities, there's no way to get for a lot of folks. So our goal, safe, affordable housing all the time, and so that means we gotta fight the evictions, we need to protect tenant rights, and we really wanna try to keep tenants where they are. And then fight to make the apartment habitable. And that's something, again, this is a real shift from back, you know, 10 years ago, we really need it. But, you know, in the past, it was like, well, if you don't like it, just move. Well, now there's nowhere to move, so you gotta stay and you gotta make it so that this apartment comes into compliance with code. Okay, Liz Marina, do you wanna run through your different clinics?
I'm sorry. So this is the Pro Se clinic that we have every Tuesday. And then we have the first and third Thursday. What I've been finding here is that there's a lot of people coming in for order to show causes, for small claims. And then every once in a while, the 7D petition, the Tenant Dignity and Safe Housing Act. And some answers, but that's what I've been seeing a lot. And then some people are just coming in for tenants' rights.
Yeah, just to understand
To
their
get an
rights.
understanding of things. Then I do the Salt City Market. That's been a really amazing. So that's always the second and last Wednesday of each month. And it's down near where the Pearl Test Kitchen is. And it's gosh, anywhere between 6 to 12 clients, depending on the day. And then this is the Tenant Dignity and Safe Housing Clinic. And at this time, I'm only doing this once a month, but I'm noticing that there's been an increase of phone calls lately. Which I'm very grateful for Not Hill. And I'm trying to put together a clinic where we could get a couple of attorneys and then do like a massive 70 for folks. So far I have 4, but they're scared. They run scared, you know.
Cause people are afraid of getting evicted.
Yeah.
If they complain. With this one, one of your former coworkers, Jen and Viet Hoffman used to do
Oh,
this a
yeah.
lot. So while this is not a clinic that is one that you regularly rotate through, if you're really interested in helping with working on housing repairs and forcing repairs of serious habitability issues, let Luz Marina know, and you can become one of the folks that she calls on when clients reach out. We would love to have it back to being twice a month, so, yeah. Okay, so we're gonna run through some of the basics, because it never hurts to just get a refresher. So you'll recall that in eviction, there's two kinds of eviction, there's holdovers and non-payment. Non-payment is probably about, I wanna say 60%, 60 to 70% of the cases that we see. And that can be cured with full payment, so as long as we can get them current, then that goes away. Holdovers are more difficult. This is either the landlord just terminating the tenancy, and in most cases, our tenancies are month to month, so they gave hopefully the requisite notice that they're gonna terminate it, and then the tenant hasn't left, and then they begin the holdover. But this can also include lease violations and objectionable tenancies. Those are less common, but they definitely happen. So the eviction process, regardless of which kind of eviction it is a summary proceeding, which means there has to be strict compliance with the statutory law. And it's laid right out in our PAPL, what is needed, and it's predicate notice. There needs to be an opportunity to cure, notice and petition, service at the right time. There's a hearing, and then the outcomes, it's either gonna result in a dismissal or an order warrant and potentially a money judgment. So how you break that out, for non-payments, when the rent is due, that is usually determined by lease, whether that's a written lease or just an oral month to month. It's usually the first of the month, sometimes it'll be the fifth of the month. And then they have to get a predicate notice. Since 2019, that is 2 notices. I always like to joke that pre-2019, it was just like wild. I had somebody once give somebody notice that they had to be out by writing on a pizza box lid and sliding it under their door, saying, "You gotta be out." And that was sufficient prior to 2019. No longer so. Now we have laws, which is nice. So they have to and honestly, landlords combine the two, but they formally have to do the 14-day notice served. They then have to file and serve the notice of petition and petition. It has to be personally served between 10 and 17 days before the hearing. And at the first court appearance, the tenant may request a 14-day adjournment. And the court should grant that. In Syracuse, it generally is granted without much pushback. In fact, some judges do it on their own. They're like, "Oh, it's your first appearance, we'll just adjourn it." In town and village courts, some of the judges push back about it. I think part of it is just that the courts don't gather as often, and then also there tends to be, depending on the judge, not as much compliance with the law. And so, well, that's a fact. And so if you're working with somebody, if they're in Syracuse, you can generally tell them, you're gonna be entitled to a 14-day adjournment. But usually at the second appearance, there is a hearing on the spot. It's pretty rare for them to grant second adjournments, third adjournments. Those are not required. That has to be generally consented to by the parties. And then the court's gonna make their decision. We settle a lot of the cases. We still to this day settle a lot of the cases. We'll work out stipulations where folks have more time to pay. Perhaps even the landlord will be required to make repairs before payment is made, and things like that. But from the time that, if there is a warrant of eviction that is issued, from the time that it is put on the door, they have 14 days. Or if the warrant execution has been stayed, it might be longer than 14 days, but never do they have less than 14 days. And they have the right to pay any time before the warrant is executed. And that makes the warrant go away. And if the landlord tries to go forward with it, then we help them file an order to show cause to bring it in front of the court to get the warrant vacated. So that's we'll go over it, but that's one kind of the order to show cause that you'll see, which is where the tenant either paid in full or tried to pay and the landlord refused, which they're not allowed to do. So they're coming back to the court to force the landlord to take the money to have it vacated. Questions about non-payments?
Yeah, on the 14-day and 5-day
Mhm.
notices, those can be at the same time.
They can be, yeah, I mean, the 5-day doesn't have to be formally served. It can be mailed by regular mail, but often, like, if they're going through an attorney, they'll serve them. Okay, yeah. Anything you would add to that?
I would just like to add that, payment, will vacate the warrant anytime before the execution, but we have successfully, vacated the execution of a warrant and restored, possession to a tenant that paid after he was already evicted. So
Yeah.
that's a possibility.
It is a possibility, yeah, exactly, yeah.
Just
It's very fact specific, but yeah, exactly. Don't, if somebody says I need to get back in that case, I think wasn't the person they had left town because there was a family member dying of cancer or something like that. So there has to be compelling reasons if they're already out, but it definitely can happen. So I do think a lot of when we're talking about advising people, a lot of it is like, what do you want? Do you want to get back in? Do you want to be able to stay? And then we try to employ the law in every way we can to get them what they need and what they want, you know?
Can the landlord refuse to accept a partial payment?
So landlords are not technically supposed to be able to refuse any payment of rent, but that said, partial payment is not enough to stop the eviction,
Right.
right? So
Just thinking about a situation where, and I've run into this, where the tenant has tried to pay a portion of it now, and then
Yeah.
they're promising to pay the rest soon at some point.
right.
And then they're also sort of tiptoeing around this situation where if the landlord accepts anything, it's sort of like an implied consent, sort of, that like, the eviction will be postponed in some way by taking less than the whole amount. or
Yeah, I
anything
mean,
like that.
landlords have the option not to execute a warrant, like they have even if a court issues a warrant, the landlord has to affirmatively then get the warrant from the court and bring it to the marshal's office and ask that it get scheduled. So we do regularly have situations where even after court, a tenant and a landlord might work out a further payment agreement. So it's certainly within the law to do that. Partial payment is not enough to stop a warrant from being executed. That said, we will go over good cause stays. So even if they haven't paid the full amount, sometimes you can get the time extended anyway.
Mhm.
So I guess my feeling is that it's just very fact specific, but in general, landlords are not supposed to be able to refuse payment of rent regardless of the income source or regardless of from where the rent was paid. Yeah. I know that's sort of a roundabout way of answering, because I know
No,
you're.
I mean, I think
the
that
landlord side, but.
So much of this is really, you
Yeah,
know,
it's very
fact dependent, so that's fair. You know, I've just seen weird situations where they paid a portion of it and then they had an understanding
Yeah.
that the other portion was going to come, and
And then
then
it didn't
something
come.
happens and the landlord's now mad.
Right.
And then they're pointing to the fact that, well, you didn't pay me
That's right.
all of the rent.
Yeah.
But the tenant's like, well, we had an understanding or something like that, and.
Yeah, and we always advise tenants to try to get everything in writing,
Yeah.
ideally via text message or something that can be printed and shown to the court, but yeah, cause it can get messy. I mean, the landlord-tenant relationship should be a very professional business relationship, but the reality is that it rarely is. So there are things that are worked out and then people get, even if they are sticking to it, people get mad at each other. I mean, it can get very messy. So that's why we always try to encourage people to just like put it all in writing and ideally work out payments, payment systems where it's recorded. Because we still, even though, I mean, we're not covering all aspects of landlord tenant law. I mean, it is required that landlords provide tenants with receipts for all payments, and to this day, we still have landlords that don't do that. And it is required that landlords maintain a ledger of what's been paid, and we still have landlords that don't do that. When we ask for a ledger, you'll get a piece of paper with handwritten note. So
And maybe you'll get to this or maybe not, but to what extent is that a defense? If the landlord can't produce receipts or something like that?
I mean, it definitely can be a defense if we have proof of payment in some way and then they say they didn't, then we definitely.
So if I have a cash tenant that claims that they paid a certain amount of cash, but they don't have a receipt and there's no way to demonstrate payment of cash.
Again, it becomes very fact specific. We employ like a lot of different methods to try to prove that, even down to like if they have a bank account, bank statements, if they have a family member that was with them when they handed over the cash, proof of that, things.
Yeah.
Often, I feel like these days, they'll often be text messages. One way or another saying, hey, I'm on my way, or hey, come in with the payment, or
Right.
I don't know. Any thoughts you have on that?
I've seen,
Oh.
yeah, it happens. Yeah, if you don't have full payment, they can still execute the warrant. The judgment needs to be satisfied in full. And actually, I've seen a really sad case this time. The client got partial payment promised by Catholic Charities. So he could pay like $3,000 and he could pay like the $2,000 rest to satisfy the judgment and be able to stay. But the landlord refused a partial payment from Catholic Charities, and I don't know if you're familiar with this, but Catholic Charities, if they refuse, then the money goes somewhere else. So when he.
Even if it's an unlawful thing to refuse.
But it happens and the money was not there anymore, so.
Yeah, I'm glad you mentioned that, because that's, I guess, more articulately is kind of the situation that I had in mind. So,
Yeah.
and like you just said, I mean, it's technically unlawful, but.
then, yeah, it's problematic.
Yeah.
And our program, that we're funded through right now does have some emergency rental assistance to avoid eviction. So that's been really helpful, where there's parts that need to be made up, maybe the tenant's got a couple $100, maybe they can get a little bit from the county or from Catholic Charities, and we can make up the difference from the funds from it's from OTDA, so.
Okay.
Yeah. All right, so going on to holdover evictions, very similar in terms of the steps that it takes to get through it. But the predicate notice is different. The predicate notice now is based upon how long the person has lived there. And so before the tenancy is terminated, they need to give 30, 60, or 90 days notice. So a year or less, 30 days, greater than a year but less than 2 years, 60 days, 2+ years, 90 days notice. And this is also the amount of time that's required for increases in rent that are more than 5%. So they give the notice. This actually, the predicate notices are it's a very common defense in holdovers because they often mess up the predicate notice. I've even had ones where they gave notice but then didn't act on it and then decided a year later to act on it, and that case got thrown out. There's got to be it's got to be connected in terms of when the notice is and when the eviction's happening. The tenancy ends, and then the landlord cannot accept rent between the termination and the filing. Those usually happen within a week of each other, but if the landlord were to receive the rent in that 1 week, then the tenancy is reinstated. And so that is an argument that we do have come up some. Again, same notice of petition being served 10 and 17 days between the hearing, between 10 and 17 days before the hearing. Yeah.
Does that apply even if there's back pay due? And the landlord claims this is on account of, like, obviously naturally claim this on account of back pay, not accepting rent for.
So that would be a very factual argument that would need to be argued in court. I would argue that any acceptance of rent between, like, say, if I were to say you have to be out April 30th. And then, I file May 7th. Any acceptance of the rent in that time period, I would argue as a lawyer is a reinstatement of the tenancy. And we're usually successful on that. Like if you can prove money was received during that time, it usually reinstates the tenancy and they have to go through the process of giving the notification again. Even if they want to apply it to back rent, which I know sometimes they do want to do. The best way to advise a tenant around how to avoid that is to tell them to write on, like if it's a money order or a check, to write on it, May rent, May 2025 rent. Because the landlord can't apply the money to back rent if it is indicated on it which month it's for. They have to apply it to that month. Again, they're entitled to the adjournments and then with the holdover, you're really just looking at if there's an order, it's an order and a warrant. We have seen some landlords try to claim both holdover and back due rent, and in Syracuse, they don't play that. There's no money judgments. Okay, so we do have in the little box of materials that you will have at court, we do have a written request for an adjournment. Again, most of the judges at this point, all of them grant 14-day pretty automatically,
Yeah,
right?
they do, they say with this exact words, the statutory 14-day adjournment.
There you
So
go.
they always do
Yeah.
it in Syracuse City Court, unless the tenant waives it. But
Yeah. But we used to have it when Judge Bogan was on the bench, she always would start asking people questions. And it was like deeply problematic because then they would basically waive all their defenses. So we've always really held the view that ideally tenants should file a written request for an adjournment and then not say anything at all. Like, do you owe the rent? Sorry, I need to talk to a lawyer, And so that's what we advise people. When they get called up, hand the request for the adjournment, say I want a 14-day adjournment to get a lawyer, I'm reserving all of my defenses. And if do the new judges ask any questions?
they go and ask questions.
Good, I'm so glad.
Yeah, they're better at that.
But if a judge were to start asking them questions, did you pay, do you owe this, did you receive this notice, which is what Judge Bogan used to do. Then we would advise people to say, I want to talk to a lawyer first, because quite frankly, they might not owe the rent. Like if the habitability issues were bad, then they have the right to request an abatement and they don't owe that rent. So we always tell people to talk to a lawyer first. Sylvia pointed out this one, that the landlord often asks to amend the petition on the spot to add additional months of rent that might not have been on it if it's a non-pay. And the tenant does not have to consent to, the landlord would have to file that request in writing if the tenant doesn't consent. And so we usually don't consent unless we're coming up with a settlement agreement. And then we incorporate it to avoid any future filings.
If the tenant doesn't consent and they put in something in writing, does the court usually grant it or?
I think it would just depend. I mean, I've never actually seen, have you seen people?
No one puts it
Landlords
in
put it in
writing,
writing?
but they might start doing it because we've been objecting and we've been advising clients to object to any verbal amendments of the petition.
Yeah.
Yeah, we haven't seen it yet, but I don't see why they would deny.
Yeah, they would
Yeah.
probably,
But
as
most
long
of the
as they had
landlords
proof.
just,
Yeah.
if they have to put it in writing, they don't bother.
That's correct.
Okay,
Yeah.
good to know.
Okay, we do have a form drafting tool, that we'll show you briefly. And this is just for the answers at this point, although at some point we will get the, orders to show cause up on this tool as well. It's super easy, it's on our computer in the room. Do the folks end up using this at all?
Well, a lot of people like to do the.
Do it by hand. Yeah.
I don't, the way.
What's really nice about this is that we do have an info sheet that we can give to the pro se litigant summarizing what the arguments are, but so say that it's a non-pay, you'd click both the answer for the non-payment pro se and the info sheet. And then it just will ask a couple of questions, you know, you'd go through test client, index number, street address, petitioner's name, client's name again, bonded tenants, and then opposing party, and then it goes through and just asks you to check off a couple of, like, what the defenses are. And so this is why we don't give this out to the public, because they would need to know what the defenses are, but you know what the defenses are. Because you are lawyers and we give you our wonderful cheat sheet of what all the defenses are, which is right in here. Under the common defenses and eviction, we have a couple of pages, there's the general ones and then the non-pay and the holdover ones. So keep that cheat sheet on you. Um. Zip it, but, okay, so it'll say answer type, document type, answer, and then we have just like easy checkoffs. So, say it was habitability, they also made partial payment. The reason it was partial payment is because the landlord refused income based on income discrimination. And then anytime you're having a habitability case, you should do a counterclaim on habitability as well. And you can counterclaim on income discrimination as well. So you just go through the list and check off the relevant, the relevant defenses, but those are the most common. And you click submit. Submit is gonna generate the documents. In this case, it's gonna email them to me, but I think the way we have it set up is you can actually download them right
Yep.
there on the computer. And then, let me see, it'll take just a second to pop up. Emails, right? Well, I can show you because I did a fake one. The info sheet and the non-pay are very simple. So with the answer, once it pops up, you just have to go through, it'll be auto-populated with almost everything, except for we have highlighted what you need to do. So you have to insert responses to the petition. So the petitions are numbered. This is just your basic answer. You go through, I admit paragraphs 1 through 4, deny paragraph 5 and 6, have no information as to paragraph 7, that kind of thing. And then you go in and it gives the defenses. It's already got the law cited regarding warranty of habitability, and then you would go in and you give the specifics of what the issues are, these repairs that need to be done are, and you just literally go through the client and say, okay, like what is wrong? Oh, we've got a broken window in the living room, the refrigerator doesn't work, there's black mold in the bathroom, like literally you just list sewage in the basement, rat or mouse infestation. I mean, these are just the regular things we see all the time. And then for the second defense, part of the rent has been paid, and then first counterclaim, tenant dignity, and you're just gonna list the issues again. And why the landlord knew or should have known, like the tenant told me. Yeah, the tenant dignity does not actually require, and habitability doesn't require that they have called codes. They can just, ideally, they'll have a text that says they complain to the landlord, that kind of thing. If they call codes, it's even better, and certainly the judges prefer to see a code list what's going on. So this is a really great tool. It's just there to help you. You don't have to use this if you don't want. You're also welcome to do the check. There's like a 1-page answer that's just checks that can be done. But I think that this is a stronger, I think these answers are stronger. And then the info sheet just lists out what you have listed for, and now see, I didn't do this version I didn't do the income discrimination, that's why you're not seeing it, but the income discrimination would have popped up if I had on this earlier one. And you're able to type in here additional guidance to the tenant, like habitability, withheld rent because of codes, and then you could write in like, make sure you bring pictures, make sure that you tell the judge about each of these issues and the effect that it's had on your life, that kind of thing. And the reason why we're doing these answers, although like Verna said, it's less common than the order to show cause in this setting. The reason we're doing it is because there are not enough attorneys for all the lawyers. So there are people who still go unrepresented in court. Okay. Then you tell people to file and serve the answer. The easiest thing is to have them just go file it upstairs in the city court clerk's office. But they also can file via electronic document delivery system, and you can help people scan and upload that right away. That's easier if the attorney is represented, or sorry, if the landlord's represented, because then they have the attorney's email and they can just email it. All right, second appearance, hold on, I need to make this thing disappear again. Okay, if you're helping them with the answer, it's because they likely have already done their first appearance, and so you want to advise them what's going to happen during the second appearance. You're gonna really advise them to have in mind what they want. It's so critical for them to really have a clear articulation of the theory of their case. And why I say that is we will often see unrepresented tenants go up in front of the judge and they want to stay, but then they feel pressure to leave and they're like, fine, I'll just leave, and they might not push their defenses as strong as they could. Because they get sort of so intimidated by the situation. So you really do want to talk people through like, what is it you want? Do you want to stay? Let's talk through how that could happen. Where are you going to go to apply for assistance? How much additional time? How long, if you're going to put together the money, how long will that take? If you want to stay and there's habitability issues, which ones do you care a lot about getting fixed? And then why don't you advocate for those to get fixed before payment? That kind of thing. Really lay it out, and ideally, either on like a typed up page or handwrite out for them what they should say. Because who doesn't get a little intimidated in front of a judge? Even as a lawyer, that happens a lot. So it's very intimidating situation for self-represented tenants. Especially if the landlord is represented, which in the city of Syracuse, most of them are represented. And I guess I should say the ones that aren't represented, those landlords are often even worse because they're super intimidating and are there like yelling at the tenants in front of the judge. It can get very unruly. Okay, we always encourage people to try to talk to your landlord to settle for what you want. And if they won't settle, just go and advocate to the judge. And really encourage people to bring their proof and also to start with the strongest defense, which you can look at. We'll have situations where tenants, they're really upset about something like a landlord being disrespectful to them. They want to have their day in court to air that. But realistically speaking, they can get the case dismissed because there's no rental registry. And so we have to just tell them, don't even talk about the disrespect. We just need to get rid of this. Just bring up the rental registry, because at the end of the day, the judge doesn't really want to hear about their entire experience. They just want to know the legally relevant issues. And so we try to do a lot of coaching with the tenants, both with pro se tenants ahead of time and quite frankly, with the tenants that we represent. We're like, I know that you meant that this is the thing that matters to you most, but we're gonna win on this other issue, so we're not even. We'll put that in the writing, but we're not even gonna really talk. So. All right. Okay, orders show cause. These are probably the most important part of what you're gonna be doing. And at this point, the orders show cause, we have you do them by hand. We have an example in the packet here. Order show cause, and I wrote some notes on it. So this is a court-generated form that's gonna help you fill this out to do the order to show cause. This is almost always post an initial eviction proceeding, but not always. So the most common things that you're gonna be filing order to show cause on is to vacate a default judgment. So this is when somebody missed court and it went forward without them, either on the first appearance or on the second appearance. And they have to either have a reasonable excuse for non-appearance, or there needs to be a lack of jurisdiction, there was no service, okay? And it doesn't even, as you know, it doesn't matter if they knew about it or not, if there was no service, there was no service, right? So, the reasonable excuse for non-appearance, most of the people who don't come to court do have a reasonable experience, a reasonable, excuse. It's often that they were in the hospital or they were out of town, they, you know, whatever it is. I mean, they even could say, I couldn't get off of work, I was gonna lose my job. That's not as compelling, but, you know, even that, judges, especially if it was on the first appearance, judges are more inclined, and they just missed it by a day or two, judges are more inclined to reopen it and hear the case than to go forward on the default, especially if it's a timely filed order to show cause. If you do this order to show cause, you do need to include an answer. So you would do these order to show cause documents, and you would need to file either an answer, which you can use the drafting form for, or a motion to dismiss. Motion to dismiss, you can use the drafting form as well. You just say no service, and then it turns into a motion to dismiss instead of an answer, right? The next most common ones, this is what we were talking about, vacating the warrant because rent has been paid in full. And this can be while they're still in the apartment, or even if they've been recently removed by the marshal. If they paid in full, they still should be able to get restored to the apartments. With that one, you don't have to do an answer because you've already answered. This is post. This is post the warrant having been posted. This would literally just be an order to show cause pursuant to RPAPL 749. I paid the rent in full, you know? And that information you would put here on the affidavit in support. Reason for the application. It doesn't have to be long, it doesn't have to be crazy, it really can just say, you know, vacate the warrant under RPAPL 749 because rent was paid in full before the execution of the warrant. And then if they have receipts, attach them, of course. Another one that unfortunately we see a lot right now is this request for additional time, good cause stay. So this often happens where somebody agreed to move out maybe or even if they didn't agree, even if it was on order of the judge, say they got 3 months. For 3 months, they've been looking for another apartment, they haven't found an apartment, and now they're a week away from eviction, they're gonna end up homeless, they got nowhere else to go. More often than not, if you file an order to show cause at that point, the judge will reopen it and will grant more time, as long as you can provide proof that they've been looking for an apartment, or proof that there's an extreme hardship. It's one of the two. It's either like, we've been looking a ton and I can't find it, or there's an extreme hardship. So maybe they're very sick, or leaving right then would result in their kid having a disruption in schooling. And would have to, move to a new school district. The ones that are listed here are directly from the statute. So these are very, very fact specific. Usually if somebody comes to me and says they need more time, I'll ask them, I need you to actually write out every single apartment that you've applied to and the dates. Or I will say, if they say they're undergoing, they just said, we've got clients that have knee surgeries, cancers, family member died, like whatever it is that is the hardship, you got, the more proof you can provide, the better. And then the other thing is the judge does have to take into account any substantial hardship that would happen to the landlord. So usually what the judge will say is fine, we'll extend the warrant another 3 months, but you have to pay occupancy during that time. And if you don't pay occupancy, which is usually fair market rent for those months, then they can accelerate the warrant.
So say they had 3 months and now they're asking for this.
Yeah.
Do they need to have paid during those 3 months?
Not
leading up to-
necessarily, not necessarily, yeah. The judge will look at it independently. So we've had ones where,
Even if you owe money, the.
yeah, it just, the judge does a weighing of the hardship essentially. And the judge can, if they haven't been paying, if they're behind, the judge has the ability to enter a new money judgment. So maybe you could say, well, you didn't pay those 3 months, we're gonna add a new money judgment, and then now you have to pay the occupancy going forward. We had one very complicated case where they had extra time, but the landlord was also supposed to make repairs. And so the client didn't pay because the landlord didn't make repairs, and the landlord to, get them out, and the client needed more time. I mean, it was very complicated, went on and on. So all I can say is very fact specific, but the judges are, I would say, used to seeing these arguments now. And again, in the past, this was never even really a thing, but now with how difficult it is to find housing, it's quite, comes up more often than we would like. And so you just really gotta talk through with the client, what are the real specifics of their life and what is the proof they can get about it, Yeah.
What kind of time periods are you looking at for getting this order to show cause heard? And is there anything you can do to do it faster? Because you mentioned in particular, like a stay of the warrant, and I mean, they're usually given with a pretty imminent enforcement date. And Les and I had one a month or two ago, which very frustratingly, the woman waited until the execution date was the next day.
That happens a lot. If we get the order to show cause in, the judge will usually review the papers that day.
Oh, really?
And
Okay.
grant it or not grant it.
Yeah, and that's what we
that
had
day.
her to do,
Yeah.
but I couldn't tell her with any certainty
Yeah.
that like this is gonna get read before the sheriff shows up or whatever the case.
Yeah, they'll usually do it that same day, or if the judges have already left that day, the very, first thing
Yeah.
the next morning.
Okay,
And more often than not, I have seen that they will grant the order to show cause, at least in terms of like a quick return date to come back and argue your case.
yeah,
So usually if you're filing it, you're gonna be in Syracuse, you'll be back in court within a matter of days, wouldn't you say?
Yeah, I yet to see, order to show cause that was rejected, they normally always put it in the calendar at, again, the earliest date. Although I must say that since it doesn't pose any hardship on the tenant to stay longer, I've seen it like scheduled for the week after, but again, if you request the stay of the execution, so it's fine.
yeah.
Yeah.
Now, would that be a defense to the sheriff to say, hey, I filed an order to show cause and we have a date, like, please don't
Yeah,
remove
so-
me.
Right, exactly. So so the order to show cause would get signed by the judge that day or the next morning. And what you'll see is we, in the sample, which you have these samples there, right?
Mhm.
Yeah, in the sample, we specifically request that, service be done, ideally via email to the opposing counsel and also email on the marshal. and so we wrote in the two Syracuse marshals
Okay.
emails. So if somebody is getting an order to show cause, you should always tell them immediately email the marshal. And ideally, when we're filing an order to show cause, if it's like the next day execution, we will email the marshal and say, listen, we already filed this.
Yeah.
And they're disinclined to execute if they know an order to show
Something's
cause.
going on.
Yeah,
Cool, good to know.
yeah. Okay,
Don't know how she made out. Yeah, I don't know if you saw her back, but she was willing to go, she just wanted time to pack, it was pretty sad.
I mean, I can say we have seen these pro se orders show cause being successful,
Yeah,
you know, so it's making a difference. It really is preventing in a very tangible way an eviction. And even if it's just exactly getting more time to pack and get out because they really thought they were gonna get in another place, they couldn't, and
yeah,
I mean, it makes a huge difference, because, I mean, how many of you have driven by a house and seen all of somebody's belongings on the front yard? And the reality is there's no service anymore at all to help people move. So there used to be at various times, you know, a truck that you could, you know, from Catholic Charities, it would go and help people move their stuff so they wouldn't lose it. It's not, last I knew, that's not running anymore. So when people lose everything, they lose everything. Most people don't have cars, they don't have transportation to move stuff, and so they're starting from ground zero whenever they get their next apartment, and that's hard, right? So, okay, and then the last kind of order of show cause that does come up, it is less common, and I do wanna say that if this happens, you can help somebody fill out the form on the spot, but you also really gotta encourage them to reach out to a legal aid order, because these are really bad situations. Is when there's an illegal lockout or a constructive eviction. So what I mean by that, illegal lockout, literally, we've had landlords change the locks, and we've had landlords change the locks and lie to the court about it before. So this does happen. Constructive eviction being that they have made the apartment completely unlivable. What we'll see with this is the landlord turns off the power. That's some of what's been happening up at Nob Hill, it's turning off the water.
No water, no heat.
Yeah, no heat,
They
no
now have
water.
one, I just found this out yesterday. They have one bathroom with a shower that all the tenants are using
On the whole floor.
on the whole floor.
Yeah.
The whole building.
Yeah, so those would all be considered constructive evictions. So when there is an illegal lockout or a constructive eviction, you're filing an order to show cause under RPABL 753. And the good thing about filing this is not only can you ask to get the person either reinstated to the tenancy or get the thing causing the constructive eviction immediately fixed, but you also can request treble damages. So if they have had to do anything, if they've lost it, if they were locked out and the landlord threw away their items, they can get not only the value of those items, but 3 times the value of those items. If they can't stay in the apartment because there's no electricity, no hot water, no water at all, and they had to go pay for a hotel, they can get treble damages of that hotel cost. And the RPAPL 768 definitions of what unlawful eviction, what constitutes an unlawful eviction, and severe landlord harassment, it can reach the level of being considered an unlawful eviction. RPAPL 768 does make landlord harassment and unlawful eviction a misdemeanor crime, and also has potential civil penalties. Some tenants read that and think that they're entitled to the civil penalties. Unfortunately, the way the statute was written, it does not create an independent cause of action. And so as a result, the civil penalties are contemplated for like the AG to get. Tenants sometimes get frustrated and think I'm entitled to $5,000 for this. Well, unfortunately, the way it's written right now, that's not the case. I do think this is an opportunity for a rewrite of the law, but that's not yet happened. I think all of us get a little worried about poking at the tenant rights because we had so many wins in 2018. And I do think the intent was to create, among tenant advocates, was to create an independent right of action, but it wasn't, you actually have to say an independent right of action, unfortunately. But that law is relevant, because it does define unlawful eviction. And so I just added in like a wherefore clause where under an illegal lockout, where you would just be specifically asking not only to restore possession, but you'd be asking for treble damages and any further relief. Any further relief would include like if they wanted to order that they had to do repairs or things like that. Okay, the last thing we keep talking about these 7D actions. This is this new action. It's been around for since December of 2023. That does give an independent right of action for a tenant to sue repairs. The tenants can be hesitant to do this because sometimes that will trigger the landlord to file an eviction. That would be a retaliatory eviction unless the landlord can prove it was for non-retaliatory reasons. It gets murky, but if somebody is current on rent, then the 7D action might be the only way to really force the repairs. I will say that so the things about it, the court forms are online. We also have them printed out. It can be for any tenant or tenants. They need to have resided there at least 30 days. The cool thing about this law is you don't have to sue just the owner. You could sue the property manager. So sometimes tenants don't know who the owner is, but they know this guy Steve always comes over and grabs the rent. So they can sue Steve and Steve's company. You gotta list all the habitability concerns. Although it's really a focus on serious habitability concerns, you know, you want to start with the worst and work your way down. And you got to request an order to compel the repairs. You can request a rent abatement. And the nice thing about this is that service can be by regular mail to the address on the tax records. It can be a standalone filing or a counterclaim. We are leaning towards doing standalone filings because it puts you in front of a judge who hears all of these cases. And she'll hear the eviction if there's an eviction that ends up happening related to it as well. So we've been moving away from counterclaims towards standalone filings to get the cases moved in front of this judge who has expertise in these cases, but it can go either way. Even if it's a counterclaim, the 7D can survive the eviction case. This is critical because we'll get cases where the landlord or landlord's attorney will be like, fine, we'll just withdraw the eviction. And it's like, yeah, but we're not withdrawing our counterclaim. We want that 7D action because this is not okay. There's sewage in the basement. And then the landlord's like, oh no, you know, like that it's all about getting the accountability to get the repairs. The judge can order the landlord to pay for a hotel if the tenant needs to move out for repairs to be made. But just note, 7D actions are very slow. And there's not a lot that the judge can do to force the landlord to move more quickly into compliance. This is true also of housing court when the city sues. It tends to have a lot of adjournments, tenants can become very disheartened about it. And so anytime you're advising a client around 7D actions, you do need to manage their expectations. This is not gonna fix everything in one fell swoop. It's gonna be part of a concerted effort to get things repaired. It should be a multi-pronged approach, you know, file the 7D, but also call codes and also take pictures and, you know, really document everything. And just know that this is not, there are no quick fixes to habitability under our current law. We have info here about how to find the owner via tax records, and how to find the list of city codes violations. I think there's also a new site I'm supposed to grab, but we will get that for you all. And then we have Luce Marina's contact. So
That's my desk number. If you need my cell phone number, but just don't.
Right, of course. Yeah, exactly. Okay, any questions? That's the 10,000 foot view of what you're doing. Like I said, we do have that list of common defenses you should review. We try to make it as straightforward as possible. If you do have questions and you're there and you're not sure what to do, Luce Marina might know, and if she doesn't know, she can pull in Sylvia or Gregory, or even call or text me. I'm always happy to brainstorm on this. And we just really appreciate you all doing this. It's really making a big difference, being able to have attorneys there to help people, especially with these orders to show cause. They just very difficult for people to get in with an attorney and kind of file one. Cool. All right, thank you all.
Thank you.
Good to see everybody. Good to see you too.
Oh, no, did my recording stop?
Oh,
No, it didn't.
Oh,
Here it
okay,
is.
okay,
Wait, I think.
And I emailed you, I think you're on
Yeah.
for June.
Ah,
there
there
it
it was
is.
good. Phew.
Okay, good.
Every swap.
I know.
Thanks for coming.
First, the week before. Okay.
Yeah, of course.
Double swap.